is now in session.
Before we call the case, we had just a brief technology problem. If something else should arise, we'll just take a pause and work through it and pick back up. It's working very well, though, so don't really anticipate any. Mr. Hivner, call the case, please.
In re Estate of Shelton D. Ramey.
We'll hear from the appellant.
Okay. All right. Thank you, sir. May it please the court. My name is Elliot Schuchart. I represent the appellant David Ramey in connection with this case. Mr. Ramey is the beneficiary of his father's estate. His father died in late 2018. The appellees are the probate trustee, Dustin Krause, and then in addition, there is a Chapter 7 trustee who is also an appellee as well. My client was in a Chapter 7 bankruptcy case at the time that his father died. So as a result, the asset consisting of his interest in the estate became an asset of the bankruptcy estate. Well, in this case, my client, David Ramey, is objecting to the fees that were awarded to the probate trustee, Dustin Krause. The probate trustee was awarded approximately $33,000 of fees in connection with the probate case. And we're objecting on the grounds that we believe that there was a significant breach of fiduciary duty by both Mr. Krause and by the Chapter 7 trustee in this case. But we're not objecting to the Chapter 7 trustee's fees in this case. We're simply objecting to the probate trustee's fees, Mr. Krause's. And the reason for that is we believe that this case is a classic case of breach of fiduciary duty because the primary asset of the estate was a house that was worth about $220,000. Mr. Krause sold that house for $166,000 in an unadvertised private sale to another attorney. And approximately 40 days later, the buyer of the house removed the kitchen from the house, gutted it, he ripped out some of the walls, put it on the market within just a few weeks, and resold the house for approximately $50,000 higher than the amount that Mr. Krause sold the property for. So the reason why I say that this is a classic case of breach of fiduciary duty is the case matches the facts of two prior cases that this court has previously heard. And in those prior cases, Branham versus Akins, which is 978 Southwest 2nd, 554. In that case, the administrator of the estate sold a house for substantially below fair market value, as in this case. They made no effort to market the property or to determine its value. And this court, in that case and in the opinion, found that there was a breach of fiduciary duty, emphasizing the fact that there was no effort to market the house and no effort to determine the value of the house. There was another case, which was a 1991 case, Alexander versus Nelson, 825 Southwest 2nd, 106. Also a case from this particular court where the trustee again sold property of the estate for substantially below fair market value. It was a private sale, as in this case. And again, in that case, the court found that there was a breach of fiduciary duty. So what do I have?
Counsel, were both those cases cited in your brief?
The first one is, the second one is not, Your Honor.
All right. If you will, just send a letter to the court clerk. Just saying this is a case referenced in the oral argument, give the case name and style of it, and copy it to opposing counsel. Don't make any argument on it. Just give us the name of the case and the site.
Okay. All right. Thank you. Yes, I will. All right. Thank you, sir.
I have a question for you, counsel. Talking about your argument is that that Mr. Krause, sold the house for under fair market value and didn't really do anything to market it. But isn't there evidence in the record that he spoke with several real estate agents and they all said they would put the house on the market for, I think, $150 or $155, and he felt like selling it this way, avoiding the realtor fee, was basically the same thing you would have gotten out of if he put it on the market?
Yes, there is testimony in the record that he did talk to several real estate agents, but nevertheless, and there is testimony that one or more agents said that the house was worth approximately the amount that was sold, the $166,000. We believe that there's nevertheless a breach of fiduciary duty in this case because the market itself determined that the value of the property was at least the ultimate sales price, $212,000, approximately 40 days later.
I'm sorry, but was there any proof as to how much what work was done and the difference that work made in the value?
There was some testimony as to the work on the property. There was in my opinion, there was very little work that was actually done. The testimony was that the buyer of the property removed the kitchen from the house and then removed certain walls, and then it was placed on the market completely without a kitchen and completely without these walls with exposed wiring, and nevertheless still sold for $50,000 higher than the price that Mr. Krause obtained. So now there was, during the hearing on this, we asked what efforts that Mr. Krause took in order to market the property. He admitted that he, of course, did not hire a real estate agent. He did not list the property on the MLS multi-listing system. He did not market the property on any other kind of online platform, such as Craigslist. In addition, he admitted that when we asked him, did you look at the comps for other properties? He admitted that he did not even look at the comps for the property. He admitted that that there was essentially no efforts to market the property and no efforts to even determine the value of the property. That's why I describe this case as essentially a classic case of a breach of fiduciary duty, because it fits the pattern so well in terms of those other two cases that I had cited earlier.
Counsel, let me get to a very, I guess, a basic question here, basic issue. What is your client's standing to bring this suit?
Yes, a very excellent question, and thank you, Your Honor. Now, the lower court judge found that my client did have standing in this case, and he found that we had standing on the basis of a residuary value of the probate estate itself. And so in other words, we have the various creditors or claimants in the estate. They would be, of course, the creditors of the estate itself, and then there would be the Chapter 7 trustee who would be paying off my client's Chapter 7 claims. But then there should have been a residual amount that would have been paid back to this estate after the Chapter 7 amount had been paid off. There were about three. All
right, make sure I understand. So your client's standing was that there might have been something left after the bankruptcy.
That's right. It's essentially the residuary claimant in the case. So there were about $300,000 of property in this case, and the bankruptcy claim was only for $45,000. So it was plausible at the commencement of this case that there would have been a significant amount of value that would have come back to my client within this particular case. And as it's worked out, they're proposing to pay my client $0 as a result of what we believe is essentially mismanagement of the case. Now, there's a second reason.
I'm sorry, go ahead. Finish your sentence.
Okay, there's a second reason why we believe that we have standing in this case. In the bankruptcy case itself, we did a motion for abandonment of certain property. And that the Chapter 7 trustee, who's claiming to be standing in the shoes of my client, abandoned to my client various personal property for this estate. In addition, there's currently a pending portion of that motion for the abandonment of a vehicle as well. So that was approved in August of 2019. So we do believe that on the basis of that, we have an actual approved interest in this estate from the bank. I
understand. Explain that to me a little more. The bankruptcy trustee abandoned the claim as to certain property.
Yes, that's right.
Certain property.
So in other words, my client had.
How does that give your client standing as to the real estate? I mean, to the rest of the claim? I mean, the bankruptcy trustee abandoned just this small portion, right?
Well, that's right. Yeah, yes, they abandoned a small portion of personal property, arguably a vehicle as well. But primarily, our standing is based on the residuary claim in terms of what should have been returned to this estate from the bankruptcy estate itself. I see I have six seconds left, so
Yeah.
I'll reserve my sections.
Good 6 seconds. All right, counsel, you have your time for rebuttal. We're here from the appellee.
Your Honor, my name is Ryan Gerard. I'm representing the Chapter 7 bankruptcy trustee in this case, Michael Fitzpatrick. I'm going to be addressing 3 issues for approximately 5 minutes, and then Mr. Krause will be addressing the additional issues with the balance of the time today. The first issue that I'm going to address is the issue that Judge Sweeney has brought up, is that the appellant lacked standing due to the fact there's a Chapter 7 bankruptcy that's been filed. The second issue is that a third-party administrator is not an agent of the Chapter 7 bankruptcy trustee, but rather is an officer of the court. And the third is that there's a probate exception that applies in this case, eliminating bankruptcy oversight requirements. That is the basis of the appellant's arguments for breach of fiduciary duty. With respect to some brief facts, the appellant filed for Chapter 7 bankruptcy relief on December the 6th, 2018. My client was appointed as the Chapter 7 trustee at that time. The appellant's father died on December the 27th, 2018, and the interest in the testator's estate became part of the bankruptcy estate pursuant to 11 U.S.C. 547A5A. Mr. Fitzpatrick moved to have an administrator CTA appointed on March 1st, 2019, due to the fact that the appellant took $14,000 of the testator's bank accounts, took possession of a 2012 Dodge Ram, rekeyed certain state assets, attempted to sell assets on Facebook, moved assets to a storage unit, and gave a race engine to a friend, which has never been recovered. The order that appointed Mr. Krause also required the appellant to turn over certain assets, and Mr. Krause's power to administer the estate comes solely from the probate order and not any order from the bankruptcy court. The first issue I'm going to address is the fact that Mr. Ramey lacks standing to bring this appeal. As this court is aware, when a Chapter 7 bankruptcy is filed, an estate is created consisting of all the debtor's non-exempt estates, and the trustee is a representative of that estate, and that's found at 11 U.S.C. 323. Pursuant to 11 U.S.C. 541A5A, an appellant's interest in an estate can come in if somebody dies within 180 days of the filing of the bankruptcy estate. Case cited in my brief, Hedrick versus Bradley, is from this court, and it has stated previously that a debtor does not have standing to pursue claims that ultimately belong to a bankruptcy estate. It confirms that the bankruptcy estate does consist of all assets that is brought into the estate, and that once a trustee is appointed, the trustee succeeds to all causes of action formerly held by the debtor, and the debtor lacks standing to pursue. In this case, Your Honors, we would state that Mr. Fitzpatrick, not Mr. Krause, has appropriate standing to object to Mr. Krause's handling of the estate, and Mr. Fitzpatrick does not object to the handling of it. As this court is aware, standing is a judicially made doctrine that allows a court to refuse to hear the merits of a case, irrespective of the correctness, where a party advancing those statements is not properly situated to pursue that action. And quite simply, as was asked previously, Mr. Ramey simply does not have the ability to object or to even bring this appeal, because Mr. Fitzpatrick essentially stands in his shoes by operation of the bankruptcy code due to the fact that he filed for Chapter 7 relief. The second issue I'm going to address today is that Mr. Krause is an officer of the court, not an agent of Mr. Fitzpatrick. It is well settled law in the state of Tennessee that an appointed administrator is an independent officer of the court and does not serve a particular beneficiary or creditor in a probate estate. The power arises specifically from letters of administration that come from the probate court. I'm citing from Pritchard's with respect to that, and that's also cited in my brief. The administrator's power is derived wholly from the court appointing him. And as I've got limited time, I would point the court out to the Hewlett and Lassiter cases that were cited in my brief, as they state that this rule goes back to 1830, and the Lassiter case in particular goes on a very lengthy description as to how this process originated from the courts in England, and that a probate administrator was an agent of the English crown to find assets for the benefit of the court, and those processes were carried over here. Also of note, there are no cases cited by the appellant stating that this long-standing rule should be overturned. And there was an agreed order to that effect that was entered on 9/9 of 19, found in the record at 226 and 227. Finally, with my last minute, there is a probate exception that applies. that is found in the Marshall v. Marshall decision, that is a United States court precedent that goes back to 1946, that recognizes that a federal court does not have probate jurisdiction to administer assets and estates and does not have any advisory authority to oversee an administrator. The appellant's arguments largely rely on application of federal statutes in the bankruptcy code to state that Mr. Krause acted inappropriately, and put quite simply, Your Honors, the probate exception prevents that particular type of bankruptcy oversight, and the cases, in the code cited by Mr. Schuchart is simply inapplicable based upon this exception. I see that I've got approximately 5 seconds left. I yield the bulk of my time to Mr. Krause.
Krause, we'll hear from you.
May it please the court, I'm Attorney Dustin Krause. I'm the appointed administrator CTA on this case. I kind of had an outline of how I'll argue this, but based on what's been discussed today, I'll try to focus on the two main issues first. This one being supplementary to what the bankruptcy trustee is arguing, but we do argue that the probate court erred when it ruled that the appellant in this case had standing to raise the objection he did at the probate court. This is the sole area where we are alleging the probate court erred. In order of standing in a case, a party has to show a distinct and palpable injury capable of being redressed by the court. A bankruptcy trustee noted 11 U.S.C. 541 divested the appellant in any interest in properties due to bequest, devise, or inheritance. And both the appellant and in our reply brief, we utilize 11 U.S.C. 544D, which specifically says that non-abandoned property interests remain with the bankruptcy estate. Now, at all times during the administration of probate estate, the interest in the vehicles, the tools, the generators, and the real property were never abandoned by the Chapter 7 trustee, nor were the interest of appellant as a residual beneficiary of the probate estate. Now, I'll jump ahead to directly address, because I do think I need to, and I apologize, belabor some facts that happened at the court below. What happened, and this will address many of the issues that the appellant brings up. So on March 15th, Mr. Ramey filed his sworn statement under penalty of perjury in the bankruptcy court, stating that the house was in poor condition and is worth approximately $150,000. On May 16th, 2019, after beginning the administration of the estate.
All right, wait, say that again. Said that the house was worth how much?
In that statement, he stated that the house was worth $150,000, Your Honor.
All right, and that statement's in the record here?
Yes, Your Honor. It's at the record at 305.
Okay, thank you.
On May 16, 2019, I petitioned the probate court for just the authority to sell the real property at a price to satisfy the mortgage. I utilize, obviously an administrator CTA has the authorities granted to an executor in a will, and that includes the power to sell real property if the executors put that power in the will as well. Nobody's objected to this motion at any point. The following day, on May 17th, Wells Fargo issued their first notice of foreclosure on this property. So this happened way back in the middle of May. At this, the estate had less than $3,000 in available cash at the time. On June 10th, I sent a status email to the parties regarding my opinion of the value of the real property based on what I had discussing with the other realtors that I had been in consult with. And I offer some suggestions moving forward. Mr. Schuchart responds back, "We have no objection as long as you can give David advance notice of the sale price on the cars." That's at the record at 308. June 26th, I discussed the offer on the real property and stated to Mr. Schuchart and Mr. Ramey that formally listing with a realtor isn't feasible at this point. And this discussion was what the firm cash offers we had on the property, plus what realtor commissions, closing costs would tie up, that it seemed to be more or less a wash. And plus we had a looming foreclosure on this property as evidenced by that notice in May. On July 8th, I sent more offers that I received over the weekend. Mr. Ramey responds, "Those offers are fine if you want to go forward with it." That's a $150,000 offer. The same day, I sent to Attorney Schuchart that I have a $150,000 offer on the property, which, as I stated before, more or less lined up with what a realtor said would be the going cost if we listed it. Mr. Schuchart saying, Dustin, I appreciate the update. On July 10th, after some negotiations, I entered into the purchase and sale agreement with the buyer. It is not a complicated contract, Your Honors. It is a 2-page contract, as is cash sale contract. I forwarded this contract to all the parties, and the contract makes no mention of realtor commissions in this, which everybody had been noticed that this was not being listed with a real estate agent, despite me telling them that it wasn't beforehand. On July 11th, the following day, Mr. Ramey contacts me and says that the contract doesn't show who's paying closing costs. This tells me that they have reviewed the contract. Mr. Schuchart was attached to this email as well. The following day after that, I petitioned the court to confirm the purchase and sale agreement. The day after that, I received approval from Mr. Schuchart to the agreed order confirming the purchase and sale agreement. On August 12th, I filed a status report with the court saying I consulted with 3 different realtors as to the valuation of the property, but explicitly stated this private party-to-party contract where the estate benefited from no realtor fees. It wasn't until August 19th that Wells Fargo finally sends a letter canceling the scheduled foreclosure they had on there, and that's on the record at page 3, record at 344. The agreed order confirming the sale agreement was on August 23rd, and then on August 18th, I filed my petition for fees related to the administration of the estate. And what's interesting about this case, Your Honor, at this point, leading up to the objection to my fees, Mr. Ramey pleads in the bankruptcy court that the house was sold, quote, after repeated objections by him to the price. So that's his verb in the bankruptcy court. 2 weeks later, he pleads in the probate court that he was fraudulently induced to agree to the agreed order confirming the purchase and sale agreement. And quite frankly, they're just 2 incongruent statements made 2 weeks apart from each other. This leads us up to the December 5th hearing. All witnesses are called by Mr. Schuchart and Mr. Ramey. I'll specifically pull out where some of the main allegations are made in the appellant's brief on this. First one regarding that the house sold, quote, $50,000 below fair market value. First, we have the sworn statement under penalty of perjury by Mr. Ramey as to what he thinks the value is. Shannon Littleton, who Mr. Schuchart called a professional property flipper or investor, who actually purchased property, testified that he had the carpet, flooring, walls, electrical sheeting, and completely new roof put on the property. He testified that the house was in terrible condition when he purchased it. He testified that he believed he actually overpaid for the real property and that the purchase was a bad deal in hindsight, and that he would not have purchased the property for $166,000 and that $150,000 would have stretched. He also further testified that he did believe the property was worth about $150,000 to $155,000 at the time he purchased it. He also testified that the work he performed at home, quote, greatly enhanced the value of the property. And lastly, regarding the other allegations, he testified that he did not know me, the bankruptcy trustee, nor the trustee's counsel before entering into the sale agreement. And I would note that Mr. Schuchart called Mr. Littleton, as he says, to, quote, testify as to what the fair market value for property actually is. Joseph Wallace was also called. He's a real estate agent with 19 years experience. When asked what a willing buyer would pay a willing seller with compulsion to buy or sell, he said that he had told Mr. Littleton that about $150,000 to $152,000 would be a good fee because it needed a lot of work and the roof really scared him. That alone defeat any claims for breach of fiduciary duty or fraudulent inducement, because both of those claims require a showing of damage. And Your Honor, quite frankly, we have no showings of damages in this case. Show that every piece of evidence, testimony or otherwise, that was presented to probate court shows that the contract sale price was actually the highest price that was proven to be the value of the home at the time of sale. And I just think that's a very important factor for this court to consider. I'm seeing I'm running out of time. I do believe my brief very well outlines a lot of the problems with this appeal. We do take some subject matter jurisdiction issues with this, namely that first, the fourth and fifth issues raised by the appellant can just summarily be dismissed. Regarding Veda Odelsi, she was not joined on this appeal. Nobody's here to advocate for her. And regarding the fourth and fifth issue, really, there's no evidence on the record that the decedent lacked testamentary capacity, nor that the will was procured by fraud. And pursuant to the 31-107 appeal from grant of letters, it is my position that from the April 4th order appointing me, that the appellant cannot sustain his first two issues on appeal, because what that statute does is creates a right of appeal that did not require permission from the trial court or any other appellate court to take an appeal. And without appealing that order within 30 days, the appellant's first two issues are time barred at this point. Thank you.
Thank you, counsel. We'll hear from the appellant in rebuttal.
Thank you. All right. Mr. Krause says that there's no evidence of damages in this case, and he says that the buyer thinks that this was a terrible deal for the buyer. Well, you know, the buyer testified that he made $42,000 of profit on this house in approximately a 45-day period of time. So I'm a little surprised to hear that Mr. Littleton is claiming that he had a bad deal when he made approximately $1,000 per day on this transaction.
Counsel, let me ask you a question, though. I'm sure your client didn't intend to commit bankruptcy fraud when he said the reasonable value of the property was $150,000, did he?
Well, I'm not aware of actually that schedule, because that was not property of the estate at the time that he filed the bankruptcy case.
My question to you, though, is do you know, Mr. Krause said it's in the record that your client submitted the statement to bankruptcy court stating that the house was in poor condition, that the fair market value was $150,000.
Well, but his father wasn't dead at the time that he filed the case. I'm not aware of any such schedule.
My question to you is, did he make that statement to the bankruptcy court? I don't care when, whatever. Did he make that statement to the bankruptcy court?
I am not personally aware of that statement. Now, it may be in the record. Mr. Krause did give us a site, and I'd be very curious to look at that. But and I encourage the court to do so. But I'm personally do not recall that statement having been made. And my point being that his father's house was not an asset of his bankruptcy estate. So maybe perhaps it will later be, fell into that, but I didn't recall that him ever valuing it at that. Now, but Mr. Krause, nevertheless, is ignored one very important piece of law here, which is that in the definition of his fiduciary duty as the administrator of this estate, he had an obligation to treat these assets as if it were his own personal property. And I'm citing the case of Branham versus Akins, which is, of course, in our brief. And I'm quoting this particular court saying, the trustee is under a duty to act in good faith, with due diligence, and with at least such care and skill as a person of ordinary prudence would exercise in dealing with his or her own property. Now, what we have is a highly educated trustee here, and he's come across as very, very straight-laced and very, very by the book. Well, we've got a trustee who's claiming that he would sell his house in a private deal without testing the market for what the value of that house is. And I would contend that is a per se breach of his fiduciary duty to test the value of this house by hiring a real estate agent and by doing more. He would never put his own house up for sale without putting it on the MLS system. And for that reason, I would say that he is the proximate cause of this admitted $42,000 loss that the buyer of this house made in the 40 days afterwards. And I'm citing that $42,000 gain is referenced in the transcript at page 121 in the record. So for all of these reasons, I do believe that we have a per se classic case of a breach of fiduciary duty. Mr. Krause basically got caught red-handed. He had no idea he was going to get found out for selling this property for such a substantially much lower value than what it was. And now, let me address briefly in terms of the standing questions that Mr. Gerard raised earlier and that Mr. Kraus raises as well. The cases that Mr. Gerard cites in his memorandum of law are basically cases such as personal injury cases where clearly the bankruptcy trustee steps in and takes over the case because there is no remainder value of those. The entire value of it gets transferred over to the bankruptcy case as a result of that. He has cited no case in this particular probate context where there is a substantial remainder interest, as in this case, where there could have been potentially 50 or 100.
Well, in a personal injury case, they recover. Bankruptcy trustee recovers $10 million, and there could be certainly money left over that would go after the bankruptcy would go to the debtor, wouldn't it?
That's right, but it would go back to the debtor by means of. I recognize that. That's an excellent point, Your Honor. But it would go to the debtor by means of the bankruptcy trust, whereas in this case, the money would actually be going to the debtor by means of the probate estate. But I see my time is out. I thank you, the court, for the time today.
All right. Thanks to both counsel, all three of you. We appreciate your arguments. Mr. Hivner, if you would, please recess court till 3:30.
This honorable court is now in recess until 3:30 p.m.
Thank you.
Thank you, sir.
Thank you, Your Honor.
Thank you, Your Honors.